Hello, welcome to The Wire. This morning we are talking to Prashant Bhushan, an eminent public interest lawyer in the Supreme Court, a social activist and a founder of Swaraj Abhiyan. We are going to talk to him about his book, The Case That Shook India. 40 years ago this book came out, and 35 years in the intervening period it was out of print. The book revolves around the case, the iconic legal case fought between Indira Gandhi, then all-powerful Congress, leader of a Congress faction, and Raj Narain. Interestingly, Prashant Bhushan's father, Shanti Bhushan, represented Raj Narain in court. In the book, Prashant Bhushan details the day-to-day court proceedings in a very lucid and non-jargonistic manner, which helps us understand the implications, both political and legal, of what led to the emergency, the kind of distortions that took place within the democratic fabric of India, the constitutional structure, the stripping away of citizenship rights. So I would like to begin by asking you, Mr. Bhushan, what led you to choose this moment to reprint this book? Were there any special thoughts that you had in mind when one thinks of the contemporary relevance to what some of the challenges we are facing even today?
To be honest, there was no particular reason to reprint this book at this point of time, other than the fact that there were a number of people who had been asking me over the last several years for copies of the book, mostly law students and lawyers, etc. And since copies were not available, I had to get them photocopied and give it to them. And therefore, a lot of them had been asking me, why don't I get it reprinted? Then one of my junior colleagues, Siddharth Garg, came along and he said that he would take up this task of getting it republished, and he then took the matter up with Penguin, who were quite eager to publish it. That's how it came to be published at this time. However, in this new introduction that I have written in the book, there is contemporary relevance to many of the issues that arose out of this case. For example, one of the major issues in this case was whether Mrs. Gandhi had exceeded the limit of election expenses. The issue of election funding of political parties and candidates, etc., has now assumed renewed significance because of the changes that have been made in the law relating to funding of political parties in particular. And unfortunately, what has been done recently is totally retrograde, in as much as there have been amendments which allow foreign funding of political parties, which was the amendment made in the Foreign Contribution Regulation Act last year. And this year in the Finance Act, there are two further retrograde amendments. One is to lift the limit to donations that corporations can give to political parties. Earlier there was a limit of 7.5% of their profits. That has been removed. And the second is allowing donations through electoral bonds in order to provide for total opacity of the donor. So now,
and this doesn't have any cap, the bond?
No cap. So therefore now, not just corporations, but foreign corporations who get contracts from the government can donate any amount of money to political parties or the ruling party which has given them those contracts without disclosing, without anybody knowing that there has been a quid pro quo in this manner. So this is one of the issues there which has contemporary relevance, but there is a much larger issue which has contemporary relevance today. You see, this case led to the emergency, which is considered to be the darkest period in India's constitutional history, where fundamental rights were suspended, everybody was sent to jail, etc. All the opposition leaders were sent to jail. the press was muzzled, there was press censorship in force. Today, though the 44th constitutional amendment, which was brought in by the Janata government, has now made it not constitutionally permissible to suspend fundamental rights even during an emergency. But what is happening today under the present regime is equally dangerous because of the manner in which the press, though without press censorship, the manner in which the media has been brought under control of this government. Without suspending fundamental rights, the manner in which the rule of law is being subverted, in which freedom of speech is being muzzled, etc., by arresting people or charging people with sedition who criticize the government or criticize Mr. Modi or the various BJP chief ministers. So, and even the judiciary is being sought to be brought under control in various ways. So, therefore, it's certainly a throwback to the emergency days, though in a different form.
So this is the book, The Case That Shook India, which has been reprinted after 35 years. And I wanted to ask you about the case which is at the center of this book, the case fought between Indira Gandhi and Raj Narain. And if you can please elaborate on the charges of corrupt practice which were the center of the allegations leveled by Raj Narain against Indira Gandhi.
So, there were many allegations of corrupt practice. Some of them pertain to her taking the help of government servants for furthering her elections, for her election purposes. So, one of them was the use of various officials in the district machinery to construct rostrums for her and install loudspeakers for her election speeches. The other was using her secretary Yashpal Kapoor as her agent for her election while he was still a government servant. Another issue was using Air Force planes for flying her to different parts of the country, including her own constituency, for the purpose of addressing election meetings. Another issue was exceeding the limit of election expenses. At that time it was 35,000 per constituency. Now, of course, it has been increased to some 40 lakhs or something like that. Another issue was the use of cow and calf as a symbol for the Congress party, because that was alleged to be a religious symbol, and religious symbols were not allowed to be used, and it was held to be a corrupt practice to use a religious symbol for furthering the prospects of your election. High Court held her guilty of just two corrupt practices. One was the use of local district officials for constructing rostrums from which she addressed her election rallies in her constituency and erecting loudspeakers, etc. for that. The Supreme Court held that, look, this was clearly for the furtherance of her election prospects, and she had clearly agreed, or rather instructed by sending out her tour program, etc., that the local officials should do this for her. So, therefore, she was held guilty of this corrupt practice. And also Yashpal Kapoor, who was her secretary, he was a government servant, the High Court held that his resignation as a government servant, he had resigned just before the elections, but he resigned well after he had already started working for her virtually as her election agent. So, the High Court held that even this was a corrupt practice because she used him when he was a government servant. The High Court, however, did not hold that the cow and calf was a religious. They said that yes, cow and calf is respected, even revered by Hindus, but it is not regarded as a god.
But your father in that context actually quoted Gandhi's Go Seva, and where Gandhi had talked about cow being an intrinsic part of Hindu religion. So it was a very interesting debate, in fact, around that symbol,
Yes.
you know.
Yes, so so this is actually a gray area as to when does a symbol become a religious symbol.
Right.
In fact, in my view, the manner in which the cow is being sought to be used today by the present government, by banning cow slaughter, by having all these vigilante groups roaming around for cow protection, etc., makes it clear that it is a religious symbol. In retrospect, by contemporary happenings, one can see that in fact there are a substantial section of Hindus who clearly connect the cow with the Hindu religion, and that makes it a religious symbol. But unfortunately, at that time, the High Court did not hold it to be so. On the issue of Air Force, use of Air Force planes, the High Court held that, well, the use of planes to bring her to Rai Bareli was part of a general tour program for the entire country, and therefore that should not be held to be used for her election alone. That was a general tour program, etc. On other issues also, the High Court, so the High Court gave her the benefit of doubt wherever it could, but held her guilty of these two. But after the judgment of the High Court, of course, emergency was imposed, and then two kinds of amendments were brought. One was a constitutional amendment itself. First, of course, there were retrospective amendments made in the Representation of People Act or to the election laws, which said that any help provided to a candidate by a government servant in the discharge of his official duties will not be considered to be a corrupt practice.
So which invalidated the allegations which were brought against.
Made the corrupt practice of which she had been held guilty ceased to be a corrupt practice. So these kind of amendments were made to cover all the allegations against her, and they were given retrospective effect, so that the amendment said that this would always be deemed to be the law. And therefore, when the case came up before the Supreme Court had to decide the case on the basis of whether if that law prevailed, then whether she would be guilty of a corrupt practice. It was conceded by my father on behalf of Raj Narain that if those laws are held to be valid, then yes, she could not be held guilty of a corrupt practice. So in the Supreme Court, the whole discussion was on the validity of those laws. But apart from these amendments, she brought a constitutional amendment which essentially just validated her election. It just said that her election will be deemed to be valid, that the election of the Prime Minister will not be challenged in any court, and if it has been challenged, it shall be deemed to be valid, etc. That amendment, constitutional amendment, came in 1975, which was just 2 years after the decision of the Supreme Court in Keswanand Bharati's case, where the Supreme Court had held that even a constitutional amendment could be struck down on the ground that it violates the basic structure of the Constitution. And the court held that this 39th amendment violated the principle of judicial review, it violated the principle of democracy, etc., by just declaring it to be valid, and therefore they struck it down on the ground of basic structure. It was the first time that any constitutional amendment was struck down on the ground of violating the basic structure of the Constitution. Thereafter, unfortunately, the Supreme Court upheld the validity of these retrospective changes in the election law, even though it was argued that these also violated. You see, at that time, since fundamental rights had been suspended, these amendments could not be challenged as being violative of Article 14, 19, 21, the right to life, the civil liberties, the right to equality, etc. But my father had argued that they could still be challenged on the ground that they violate the basic structure of the Constitution, because they had been put in the 9th schedule, which made them immune from challenge on the ground that they violated fundamental rights. But they could still be challenged on basic structure. But unfortunately, the Supreme Court did not accept that argument, and that's what I say, that eventually the Supreme Court also succumbed to that atmosphere of fear which prevailed during the emergency. And on that basis, once they upheld the retrospective amendments to the election law, the election was upheld.
I think Ms. Shanti Bhushan actually argued with regard to the 39th constitutional amendment that this was something which was unimaginable in a country like India, and it could only be imagined in a country like Idi Amin's or something. It was, but of course the Supreme Court upheld.
They struck down the constitutional amendment. But that didn't make any difference to the eventual outcome of the case, because they upheld the election law amendments.
And finally, it validated emergency. But your book, for example, shows us the dangers of what can happen. What are the safeguards today you think? You've just spoken about the media, the way the media is yielding, even without such outrightly coercive methods. What are the safeguards, in your view, can we bank on to prevent another onslaught on our democratic constitution?
Yes, this is an important question. See, during the emergency, since fundamental rights could be suspended and the Maintenance of Internal Security Act, which was a preventive detention law, was used to en masse pick up and jail most of the opposition leaders, even student leaders, etc. There was this enormous fear which surrounded the whole civil society, including those who manned important institutions such as the judiciary. So, though fundamental rights had been suspended, but that did not mean that the rule of law had been suspended. Right. But it was this shock and awe and the fear which pervaded even among members of the judiciary, which made the Supreme Court, in Mrs. Gandhi's case, validate the retrospective election law amendments, though they struck down the constitutional amendment which validated her election, but they upheld the election law amendments, which was a retrospective change in the rules of the game after the game had been played. And the same fear made the Supreme Court ultimately hold that during an emergency even habeas corpus petitions could not be entertained.
This is the Jabalpur, ADM Jabalpur.
The ADM Jabalpur judgment, where fortunately high courts had not succumbed to this fear, and several judges in several high courts held that yes, habeas corpus is maintainable. Rule of law is not suspended, only fundamental rights are suspended. But unfortunately, the Supreme Court went on to virtually hold that even the rule of law had been suspended. So, ultimately, whether the institutions, that is even the media or the judiciary, stands up to an authoritarian push from the government depends to a large extent on the kind of fear that pervades the atmosphere and civil society and society in general. Now, today, even without an emergency having been enforced or without fundamental rights having been explicitly suspended, unfortunately, there is a atmosphere of fear that has been created because of the authoritarian nature of this government, which enjoys an absolute majority in parliament, which today controls many of the state governments. And the result has been that today you see large number of these lumpen violent groups which are called fringe elements of the Sangh Parivar, various senas, etc., and lumpens roaming around, beating up people, particularly those from minority communities as well as Dalits, etc., either on the guise of cow protection or on love jihad, etc. And unfortunately, the law and order machinery or the institutions which are supposed to maintain law and order are not being able to control this kind of what is known as vigilantism, etc. And this is going on unchecked because the BJP governments are supporting this kind of thing, and unfortunately the institutions, even to some extent the media and to some extent the judiciary, is not really playing the role that it should play to stop this. So, this has led to a situation which is also called by many people to be an undeclared emergency prevailing in this country today.
So, in a way what you are saying, it's a kind of normalization of quote unquote emergency like situation which we keep hearing in conversations every time there is an incident of vigilantism or attack on groups which are vulnerable. The judiciary, particularly because this is an institution you have been associated with, and you've also been quite a forthright critique of many of the mechanisms through which the judiciary functions. Would I be wrong in assuming that we have passed that moment before emergency where the judiciary actually yielded in a manner which is actually till then was inconceivable?
So, even during the emergency, though fundamental rights had been suspended and they could be suspended at that time, which they can't be today, there were some judges in the high courts, etc., who stood up. There were some sections of the media also who stood up, like particularly the Indian Express, even during the emergency when press censorship was in force. But by and large, the media as well as the judiciary were brought under considerable fear, and therefore the Supreme Court also buckled at that time during the emergency. Today, I would say that unfortunately a large section of the media has buckled under the influence of this almost authoritarian, this fairly authoritarian government which we have in place today, and therefore there are large sections which have been brought under control of the government by giving them inducements or their owners inducements of Raj Sabha memberships, etc. There are others who have been purchased by corporate houses which are cronies of the government, and those which have not been brought under control in this way, they have, a lot of them have been terrified or rather made fearful of the consequences of defying the government by way of, like what has happened to NDTV, etc., by way of income tax raids or raids by other agencies controlled by the government. Now, to some extent that kind of thing is also happening within the judiciary, though I would say that they have not yet been able to bring the majority of the judiciary under their control, but that effort is on, and the effort is in various ways. See, all kinds of means are used. Mr. Modi is prone to say that he once said, or several times said, that the opposition leaders should not speak much against the government because he has what he calls Janam Patris of all the opposition leaders with him, which means that he has information on them which he could use to blackmail them into submission, and which he has done successfully to a substantial extent. It seems that the same technique is being used for other institutions like the media and the judiciary also. And this is again just one of the things. The other is some judges just succumb to this fear or awe of such a powerful and seemingly authoritarian government. So, the way to resist it would be for civil society in general to first wake up to what is happening, that people should see that what is happening is really an onslaught on civil liberties, on institutions, on society in general, on democracy, and thereafter come together, organize themselves and fight this tendency. And also to that awakening in civil society and organization in civil society will also help people manning these institutions like the media and the judiciary to also stand up.
So there is a fundamental difference in the why Indira Gandhi did what she did. Her own personal kind of power, her hankering to stick on in power. And now what we see is it's a more, the way politics is being transacted is more through ideological channels. There is a whole ideology which seems to be in operation. The language of discourse is changing. So whether it's nationalism or whether it's your food habit or whether it's your regional sentiment, there is an overall overarching paradigm into which everybody is asking, into which people are being asked to kind of fall in within. It is a far more collective kind of effort, it seems, from the powers that be to change the thinking process, and through that, perhaps not by subverting the constitution the way it was subverted in 1970s, but when you routinize something like this in your daily life, without realizing that you have soon reached a point where the idea of India actually has kind of changed dramatically. Would you agree, or am I being too much of a fearmonger?
No, I largely agree with your analysis. See, Mrs. Gandhi was opportunistically authoritarian. So she showed her authoritarian tendencies by imposing the emergency, suspending fundamental rights, muzzling the press, etc., when her own position was threatened. But the BJP and Mr. Modi and many of these BJP leaders are ideologically authoritarian. You see, the BJP, which arises out of the RSS, and if you see their original ideologues, whether it was Savarkar or Hegdewar or Golwalkar, etc., they were essentially authoritarian, who worshipped Hitler, who worshipped Mussolini, who felt that the same kind of authoritarianism needs to be brought into India and dissent needs to be crushed, etc. If you look at the way in which some of our finest institutions of higher education are being targeted, like JNU or even Banaras Hindu University or Hyderabad University, etc., you can see that these people are targeting these universities and wanting to close them down because they see these institutions as places which allow freedom of thought, dissent, and the right to challenge the prevailing orthodoxy of our times. But they want to breed a kind of people who are just following orders, whose minds are closed, who can be whipped up to what they call nationalistic frenzy whenever they want to, and therefore, what is happening today is in many ways far more sinister and dangerous than what happened even during the emergency.
Thank you so much, Mr. Bhushan. We've run out of time. I would have loved to ask you some more questions, but some other time perhaps. Thank you very much for sharing your thoughts with us.